Yeah, good day, ladies and gentlemen. My name is Onigmide Raphael, and you are welcome to Talking Point Show. On the show today, we'll be talking about the medical negligence and its legal implications. I'm discussing this on the show. I have a barrister, Borishade Adedayo. Barrister, you are welcome to the show.
Thank you very much. Thank you so much. Thank you so much,
Yeah,
Mr. Raphael. Thank you.
yeah, you're welcome. Barrister Oladimeji Martins will also be joining us in the show. Barrister, you're welcome to the show, please.
Thank you very much. My name is Olamiji Martins. For the purpose of emphasis, my name is Olamiji Martins, and I'm so glad to be here, Mr. Raphael, in doing justice to this very topic. It has been a recurring topic. A lot of people have passed away, unfortunately, as a result of the fact that they don't know their right. So it's a privilege for me, once again, to join this forum. I'm so grateful.
Yeah, thank you so much. Thank you so much. So let me start with Barrister Dayo. What do you, or how can you explain to a layman or like a patient what is medical negligence?
Anyways, let me first state it clearly that medical negligence inked on tortious acts in law. And this was made mention in the case of CVC and Dono Group. So, and it's an act or omission that deviate from medical standard, as it were. Can you hear me over there, sir?
Sure. Go on.
Yes. In every profession, we have standards that has been set. So in medical profession, we have what we refer to as medical standard of care, or what we can refer to as accepted medical standard of care. And if the performance or acts of a medical expert is below this standard of care, is negligence, can be referred to as negligence. That's what I can say now, sir.
Okay. Barrister Martins, I don't know if you have an addition to that, please.
Yeah, Mr. Adedayo spoke well. I think that is the position of the law. I would just be adding that medical negligence goes further. Before we can say that a case of medical negligence has been established, the court always looks at the reasonability test. And how do I mean by reasonability test? The court will consider the fact that, okay, in establishing or finding a case for medical negligence, would another reasonable medical doctor have done what the current person under review, the current medical doctor under review, will he have done the same thing? If another medical doctor who is reasonable finds himself under the same situation, would the medical doctor have done the same thing? That is what we call the reasonability, the reasonable man test. Of course, it's a test that is very obvious or very obvious in the law of tort. It cut across all various law of tort, especially as regards personal injury. The court will look at if another medical doctor is in the same position or is in the same shoe with the doctor under review, will he have exercised the same discretion? Will he have followed the same pattern? Will the reasonable man test, will it be sufficient to have been manifestly seen? So it's another test. And in establishing medical negligence, there are a lot of factors that also have to be put into consideration. Number one, it has to be proven that the patient has submitted himself or herself for treatment. That is a duty of care flowing from the medical personality to the patient. It must be established that that care is established. Then another thing is that it must be established that the medical or healthcare giver, has breached that particular duty. After submitting yourself for medical treatment or a laboratory diagnosis or whichever one is applicable, it has to be established that despite that, because the medical doctor or practitioner is supposed to have a superior medical knowledge more than the patient. Now, if that duty is breached, if that knowledge or if that undertaking, if that trust has been breached, then we can also say that a case of medical negligence has been established. And that the last and the most important thing is that if that breach will cause or leads to damage, number one, I want to make a recap that there's the patient has submitted himself for a treatment. There's a fiduciary relation. There's a relationship between the patient and the doctor to submit himself to treatment or herself to treatment. And number two, that after submitting himself or herself for treatment, the medical doctor breached that particular duty, probably by a wrong laying of hands or wrong medical procedure. And the last thing is that that procedure leads to damage to the patient himself. So these three elements has to be proved and established so that the court might find in medical negligence case. Thank you.
Yeah, thank you very much. Oh, now, it's very unfortunate that most of our citizens don't really know their rights, especially when it comes to saving life. Now, what is the punishment as regards medical negligence? Ms. Barrister Dayo.
Okay, I would say first and foremost, my friend just made mention of three solid elements of medical negligence. I need to reiterate that is a must for the patient to establish these three things, as rightly stated. And talking about the punishment, after you have established these three elements of medical negligence, number one, the name. If found guilty, let me say that. If the medical expert is found guilty, the name will be struck out or maybe struck out of their register, or they may give that person suspension. Are you with me?
Yes,
And
yes.
yes, and we need to state the fact that the patient or the party in question has about three options. Are you with me? Number one,
Yeah.
it can make a complaint, speak to his lawyer, and seek for redress in court. You can seek for redress in court. Presently, we have a case we are handling in that regard, wherein our client called us that she was wrongly diagnosed, something like that happened, and we wrote a letter to the hospital in question, and we also wrote Medical and Data Council of Nigeria. Yeah, we wrote them a letter to let them know what is going on. And we are ready to even go to court because we have all these three elements. We can easily establish our case moving forward. So number two, you can also, as a patient, make a complaint to maybe police force. They can take it up from there. Number three, you can make a complaint directly to that Medical and Dental Council of Nigeria, wherein they will set up a tribunal to listen to you, to hear you, and they will call the medical expert in question to defend. You know, ESA as it were is very, very important when it comes to things like this. They have to listen to the two parties to the matter and to know whether or not the medical expert made mistake or committed an error. And I think fourthly, you can also address this through alternative dispute resolution, ADR. You want to settle this matter amicably without going to court, without seeking for redress in court. Are you with me, sir?
Yes,
and
sir.
so about that. But I know, number one, the name can be struck out. So you are no more a medical practitioner, which means you cannot practice anymore as a doctor or a medical professional. Secondly, you can be suspended for 6 months. So that's all.
Wow. Okay, now, Barrister Martins, for clarity's sake, you know, some people can be arguing maybe their actions, what they have done, that no, I'm still on my right. Can you please give an instance, maybe if this kind of things happens, is referred to as medical negligence?
Okay, thank you very much, Mr. Raphael. First, let me say that the reason why most people, I just want to chip in this. I remember one of my lecturer's favorite quotes when we were in school, when we were doing medical law, Professor Uwaku Abubu. He used to say then that once a case of medical negligence has been established and patients who may likely due to the fact that they don't have money to pursue the matter in court, or for religious purpose or reasons, who may also deem it fit to just abandon the case and let it slide. I remember Professor Abubu said, and I quote, if you decide to leave what you're supposed to do undone, and you decide to leave everything to God, God will ask you on the judgment day where you left what you meant to be done, what it's meant to be done undone. I want to come from that aspect. A lot of people are suffering in silence and they don't know. A lot of people are passing through some medical malpractice and they don't know that they have locals to sue, or they have right to enforce this right. Let me start by saying that it is wrong for a medical practitioner or a healthcare giver to lay hands on a patient without seeking or getting an informed consent. I want to make it clear. There is what we call consent in medical practice. There is what we call informed consent. Now, let me distinguish between these two. Consent could come orally or in writing, but mostly they have been encouraged. Medical establishment have been encouraged to make it right in written, because anybody can deny. If you make it an oral consent, anybody can deny that you did not inform of the procedure you want to embark upon. But anything that has been reduced into writing, it's very difficult to deny, except you want to prove a case of forgery here. Just like I'm saying, it is wrong for a medical practitioner or a healthcare giver to lay hands on a patient without getting an informed consent. And how do I mean by informed consent? Informed consent means that it is the duty of a medical practitioner or healthcare giver to inform the patient about all the procedure, everything that will be done on the patient, the procedure, the practice, the style, if it is going to be an administration of drugs, the kind of drugs to be administered, the side effect, on the long, on the middle, or on the short run. Everything has to be disclosed. There must be full disclosure without excluding none. Now, if a medical practitioner or a healthcare giver fails to do this, then a case of medical negligence arises, a case of medical liability arises. Now, it is also wrong if a medical practitioner or a healthcare giver, knowing fully well that the issue regarding the patient's health is more than what he can professionally handle, in the Hippocratic oath being administered on all medical doctors or professionals when they are being inducted into medicine, it is there in the Hippocratic oath. Hippocrates is reputed to be the father of modern medicine. Now, it is in that Hippocratic oath that anytime that I, as a medical practitioner or healthcare giver, feel that my knowledge is not capable of offering a solution to the problem of any patient, I am under duty to refer such patients to a superior knowledge or a superior authority, and that is what we call referral. Now, for example, in UCH here, any case that UCH cannot handle, most times they refer patients to, say, United States of America, United Kingdom, or India. That is, they don't want to put themselves under medical negligence or medical breach. So it is for some doctors or some healthcare givers, because they want to put their chest out that they are capable, and they don't want people, most of our people who go for medical treatment, most of them, a lot of Nigerians are still under the literacy level. So, and they always presume that that doctor is not fit, is not educated enough. So in order to remove that stigma from themselves, instead of them to refer such patients to a higher authority, they don't want their name to be stigmatized as being unprofessional or being not being strong. They still make sure that they go ahead, and that is to the detriment of the patient. So it is wrong, medically wrong, and it is a case in law for a practitioner who knows within himself that he doesn't have the wherewithal, he doesn't have the mechanism or the instrument to give a cure or to administer proper care for the patient, not to refer him to a consultant. It is wrong. It is against the code of medical ethics. It is against the standard of the Medical and Dental Council of Nigeria, and it is against general medical medicine in summary. And now, it is wrong. And I want to cite the case of Esabuna and Fayewa now. The case was decided in the Supreme Court last year. It was a case that took a lot of time in court. Now, I want to give a brief summary of that case. Now, there was a Jehovah's Witnesses family who gave birth to a child, and that child was in need of blood transfusion. And you and I know as Nigerians that Jehovah's Witnesses, they don't allow blood transfusion. It is against their religious tenet and practice. Now, but the child was already in a coma, was about to pass to the great beyond. So when they rushed the child to the hospital, the family rushed the child to the hospital. When they got to the hospital, the doctor on duty informed them that, Mr. and Mrs., this child is in need of blood transfusion, a failure of which the child will die. And the parents said it is against their faith, that the medical doctor should find a way around it. Is there anything that you can do without accepting blood transfusion? The doctor said, well, I'm sorry, this is the only thing I can do. But the doctor did not stop at there, because the doctor owes that professional duty to give maximum care. The doctor approached the Commissioner of Police of Lagos State. The Office of the Commissioner of Police, the legal department, obtained a court order that in the interest of the child and in the interest of the state, the doctor should go ahead with that procedure. And note, the doctor did not just lay hands. Look, there is a difference between what is right and what is appropriate and what the law says. We have to clarify this. Now, the doctor knew what was right, but he also did what was appropriate. And what was appropriate in that situation was to involve the government and to obtain a court order. Armed with that court order, the doctor cannot be led liable under the law. So when the doctor got the court order, it could be so ironic and it could be so funny. Consciousness, after your child is already well and doing, up and doing, you still went ahead and sued. They went to the High Court of Lagos State. When they got to the High Court, the parent lost that case. They went to the High Court and the ground that the medical doctor did not do with their own, went ahead, did not seek their consent. That's where I'm coming from now. That the medical doctor did not get their consent because the child is a minor. And so as the child parent or guardian, they're supposed to get the consent, seek the consent, and that is the law actually. That is the law. That when there's a minor, it is the duty of the medical doctor or health caregiver to obtain the consent of the guardian or parent. Now that was the case that was taken to court. That the Dr. Fayewa failed to get the consent of the guardian and went ahead and administered the blood against the religious tenet of the guardian. Now the High Court ruled, the High Court struck out the case. The matter was dismissed. The family of Esabuna went to Court of Appeal. They had appealed that decision. The Court of Appeal dismissed the appeal. They still went to Supreme Court. In fact, you now begin to wonder that does the family want the hospital or the doctor to remove the...
Okay, I want to ask this, Barrister Dayo. We've had several cases of patients being rushed to the hospital and no doctor to attend to them. At the end of the day, we have some that give up the ghost. Some, their problem become more serious. What's the stand of law on this? In fact, it's not a new thing in Nigeria.
Anyways, let me just say that medical negligence, speaking about a doctor, cannot be committed by association, like rightly stated, Medical and Dental Council of Nigeria. So you can sue the Medical and the Dental Council of Nigeria in that case. I have a matter, I saw the case of one Mr. Eddie that rushed his way to one hospital. Getting to that hospital, they said that they wrongly diagnosed the woman that she was having malaria. They gave her drugs and she administered the drugs. 2 days after, she started feeling stomach ache, serious one. And she ran back to the hospital. They got to know that she was 7 weeks gone. 7 weeks gone. So that was the issue. The pregnancy was the issue, not that she was having malaria. Number one, I want us to note today that they have committed an error. They have committed an error. And according to the ethics of medical code of ethics of medical professionals, it is wrong to wrongly diagnose a patient. That one aside. So subsequently, she started having contraction. So because of this contraction, they ran to the hospital again. They called that same hospital, but they were turned down. Husband and wife were turned down. And at the end of the day, they decided to go there themselves. So when they got to the hospital, they met two nurses. No medical doctor was on ground. Are you with me, sir?
Yes, sir.
And they had no option than to plead with the nurses to take up their case. These two nurses had to give them what's it called, drip. So in course of that, that woman gave birth to a dead baby. A dead baby. So maybe that, you understand what I mean? So she gave birth to a dead baby. So in that case, she can seek for a redress in court against the what's it called, Medical and the Dental Council of Nigeria. My view. And honestly, I don't want us to restrict this to only medical doctors. Only medical doctors. My friend made a point the other time that if you know that this is beyond your power or this is beyond your knowledge, you can make a referral. So it was expected of these two nurses to make a referral to maybe a private hospital wherein they have doctors who were not on strike. Are you with me, sir?
Yes, sir.
So you can take the Medical and Dental Council of Nigeria to court in that regard, my view.
Wow.
So that's that.
Wow. Thank you so much for digging so much deep into this topic. I believe a lot of people will learn from this and be able to know the next action to take whenever they have such experience again. So Barrister Martins, thanks so much for coming to the show today.
You're welcome.
Thank you, sir.
Barrister Burishade, you also, in fact, you did a lot of justice to many things.
Thank you, my brother. Thank you, sir.
Yeah, thank you so much.
Thank you, sir.
Yeah,
thank you, sir.
So this is where we draw
Yes,
the
sir.
curtain of today's show. We believe a lot has been said and a lot has been learned. So join us next time. It's still your show, Talking Point Show. Thank you.